We're going to open this meeting, and I want to, first of all, thank you for all coming here, and hope the meeting is to your liking. We'll have a roll call, please.
Board members Apkarian.
Here.
Berry.
Here.
Nakasone.
Here.
Ochoa. Here. Sheehan.
Here.
Steiger.
Here.
And Chair Raggio.
Here. Report from the Secretary.
Posting of the agenda for the August 22, 2012 special meeting of the Glendale Oversight Board was posted on Friday, August 17, 2012 on the bulletin board outside City Hall. And at 1B is the selection of Vice Chair.
Mr. Lanzafame is now. Would you tell us what you're going to do?
Yes, I can maybe give
Besides,
you background. With the Association by the Regional Agency, and so you have a member of that group sit on this board. Because I have moved away from that, I am no longer eligible to sit on the board, and so I tendered my resignation to the mayor. And during one of their last meetings, they appointed my successor, Mr. Mark Berry. Mark is a senior project manager, or actually he's a principal development officer now for the city of Glendale. He's been working in redevelopment for 10, 15 years. He's probably the smartest person I know on redevelopment, excluding myself, I should say, because I've taught him everything he knows, but not everything that I know. So Mark will be an outstanding fill-in, and I would ask you all to make him feel at home here on the dais.
welcome, Mark.
Thank you.
Well, our next duty then is to elect a vice president, and
Sure.
yes.
I nominate Ron Nakasone as the vice chair.
Is there a second?
Second.
Any further nominations? And I declare the nominations to be closed.
Does he accept?
Ron, all those in favor?
Shall I take the vote?
Yes.
Board members Apkarian.
Yes.
Berry.
Yes.
Nakasone. Ochoa.
Yes.
Sheehan.
Yes.
Steger.
Yes.
And Chair Raggio.
Yes. You have a unanimous vote.
Well, thank you.
And
You
congratulations.
better stick around.
May I have an approval of the minutes, please?
So moved. Second.
Any changes or deletions to the minutes? Yes.
Yeah, I'd like to abstain. As
All right.
I'm not here.
Roll call, please.
And I'm sorry, who was the second? Oh, okay. Board members Apkarian.
Yes.
Berry.
Abstain.
Nakasone. Ochoa.
Aye.
Sheehan.
Yes.
Steger.
Yes.
And Chair Raggio.
Yes. Well, minutes are approved as stand, and we'll go to item 3.
At item 3 is informational items. 3A is introduction of legal counsel to Oversight Board, Green, Dabornowski, and Quintanilla, LLP.
And for your information in the audience, Mr. Charles Green is sitting right there, who is our new counsel, and Miss Jennifer Mazrahi is right there, also legal counsel. Both of them will be serving as counsel to this oversight board. Congratulations, and thank you for coming.
Thank you, sir.
Next item.
I believe we had a card on 3A.
Mr. Barry Allen. And since we're pressed for time, Mr. Allen, I'm going to limit you to 3 minutes.
Okay. I'm Barry Allen. As the Oversight Committee, you have an awesome task in front of you. You have the power and authority to say yes or no to the demands put upon you by the Successor Agency and staff, both of which are self-serving, as can be seen by the expectation of your decisions and the limited amount of supporting documents you have been provided. Where are the DDAs, the leases, the council approvals? Why aren't they here? What are the promises that were made? Why has the parking issue been buried in variances? Where are the financials for each project? The state has given you the tools to demand that you have all the reports, as voluminous as they may be. You have your own legal counsel, and I congratulate you for that you should go to, not to the city attorney who represents the council and the successor agency. I encourage you to take the time to read AB 1484 and not just rely on the interpretation by staff. Then you'll have the questions to ask staff about. Thank you. I'm Barry Allen. And
Thank
I
you,
will
Mr.
leave a
Allen.
copy of this for the clerk.
Thank you, Mr. Allen. Next item, please.
3B is summary of AB 1484.
You had no card, Mr. Kasanjian. Next item, please.
At 3B is summary of AB 1484.
Good afternoon, board members. At your last meeting on July 2nd, this new legislation, which is intended to clean up AB 26, was in print for only about a week, and so we did not get a chance to thoroughly go over all of the requirements. We are going to take this opportunity to go over some of the new requirements from AB 1484. Although we want to reserve a bulk of the meeting for the review of the ROPS, it is important to go over this because it does lay the foundation for some of the changes that have taken effect, which specifically relate to ROPS 3 versus what you saw during ROPS 1 and 2 earlier in the summer. So with that, we have a brief PowerPoint. AB 1484 went into effect June 27th, and it does have some new timelines for ROPS. One of the reasons you're meeting today is for us to review and approve ROPS 3 so that it can be submitted to the State Department of Finance by the statutory deadline of September 1st. There are new notifications that are required. In addition to sending the ROPS to the State DOF, there's also new requirements to submit it to Los Angeles County Administrative Office. LA County Auditor was always one of the entities we notified. We also need to send the ROPS to the State Controller's Office after it's been approved. So there's new notifications, and we did submit the ROPS after it was sent to you to these same entities as required. There's new definitions that came into play for ROPS, and the purpose of these new definitions is to clarify some of the ambiguous language in AB 26 to differentiate between administrative costs versus project-specific costs. And lastly, there's new penalties that are in AB 1484 if the ROPS is not submitted timely. It's noteworthy that the penalties apply not only to the successor agency but also to the host city of Glendale. Another requirement of AB 1484 is some additional audit requirements. You all received yesterday from LA County a audit report which is very lengthy, and that was required as part of AB 26. That was the agreed upon procedures, and our agency was the first agency in LA County to go through this audit. You have the report findings. That's not on your agenda today, and you don't need to act on it, but certainly if there are questions, we can take them, and if needed, agendize it for a future meeting. But what AB 1484 does is take that audit a step further, and it includes what are called due diligence reviews, and there's housing funds and non-housing funds that a new audit is going to be required. And the purpose of the audit is to see how much cash and funding the agencies had. Of that cash, how much is needed to pay enforceable obligation, and whatever is remaining is to be distributed to the taxing entities. Upon completing that audit requirement and paying some pass-through obligations, the agency can receive what's called a finding of completion, which is granted from the State Department of Finance. And that finding of completion has some benefits to the agency. Primarily, bonds issued in 2010, those proceeds can be spent. Up until now, they've been in a frozen state. And the reinstatement of the city agency loan, which is important because this was one of the items that was disallowed by the DOF during our ROPS 1 and 2 review. Following the finding of completion, a long-range management plan is to be put together by the successor agency, and this must be done within 6 months of us receiving the finding of completion. Both the Oversight Board and the DOF must approve this, and the intention of the management plan is for the successor agency to review all of its assets, determine why it was purchased, the history of the site, estimate the value of the asset, estimate any income that's derived from the asset, and also to look at the proposed use. There are some provisions in the law that allow some assets to be retained for governmental use, and it would allow the successor agency to transfer that asset over to the city. AB 1484 changes the organizational structure. Prior to AB 26, we had tax increment that was held by the county and then given to the successor agency, given to the redevelopment agency for project implementation. And post AB 26, there is new levels of review that are included. You know, the successor agency reviews items, then it's brought over to the Oversight Board. The county has review authority. Ultimately, the DOF and state controller has review authority as well. So this is intended to show the different layers that were added as a result of AB 26. Moving on, this next part of the presentation is to lay the foundation for what's coming up in your review of the ROPS. During ROPS 1 and 2, there were numerous questions about different funding sources, and so we've tried to simplify the different funding sources so that when we get to the ROPS, it can clarify some of the questions that you or the members of the public might have. For our agency, we're going to limit this to 3 sources of funding: cash reserves, which is tax increment that used to flow to the redevelopment agency directly from LA County; future tax increment, which is the same property taxes. The distinction is going forward, it's because of AB 26, it's funneled through the county through this new ROPS process, and so it's called RPTTF, which is the trust fund that it's held in by LA County for each agency. And lastly, our bond proceeds, which I mentioned earlier, that are restricted and can only be spent for the projects that they were issued for. Cash reserves, this is to show a flow chart of where the money is and how it gets ultimately spent. So for our cash reserves, the money is collected by LA County through property taxes, and this new orange box is to show the different approval processes that must take place every 6 months before the successor agency is allowed to spend the money and implement projects. The second half of the box shows the due diligent review process, which I mentioned earlier, because after this ROPS review period, there will no longer be any cash balances left. Whatever cash is remaining that's not committed to an enforceable obligation through the DDR process will be identified, and in turn it must be turned in to be remitted to LA County, who will then distribute it to the different taxing entities. Moving on to the bond proceeds. The bond proceeds are in possession of the successor agency. However, because of the legislation, we have not moved forward with projects because we were uncertain of the spending authority as it related to the bond proceeds. 1484 did clarify that bonds issued in 2010 can be spent, with the note that it must be after a finding of completion is received by the agency. We did issue bonds in 2011, and the statute did not clarify the spending authority, and so right now they're going to be sitting in a fund, and we continue to make the debt service until there's a clear direction on what to do with the 2011 bond proceeds.
When you say it's, I'm sorry, sure. When you say it's going to be sitting in a fund, where is it sitting? In a city?
It's in the successor agency's possession. Correct. Then lastly, the RPTTF, which is /tax increment. Again, LA County collects and holds on to it. We show our funding request through the ROPS, and it goes through the different bodies for approval. We receive the increment, and then we pay for our project implementation and operating costs. This next part I will reserve for the ROPS agenda item. So that's a brief overview of AB 1484. Ms. Van Meiden and Mr. Green and Ms. Mizrahi and myself are available for any questions.
Questions?
Question.
Mr. Ochoa.
Did the passage of 1484 change in any material way the purview of the Oversight Board? I guess what I'm asking, does the Oversight Board have any authority to oversee the land use decisions of the City of Glendale?
Well, it has the same authority in the hierarchy, except that the ultimate authority has been moved further up.
No, but I mean, looking back at a previous deal, can we somehow veto a land use decision made by the City of Glendale on an existing obligation?
Oh, the one that hasn't previously been before you, and that
Looking backwards, not forward.
yes,
Yes, what?
yes, sir, you can. If it comes forward, you can revoke it.
Let me make sure I'm understanding. If there is a deal that is an existing obligation that has been approved by the City of Glendale redevelopment before it was dissolved, this Oversight Board has the ability to go back in time and undo that deal?
Yes, sir.
Really?
If I may, as a counsel for the Successor Agency, there is a provision in the statute, it's 34181E, and it's a process that the Oversight Board directs the Successor Agency to go through, and that is to determine whether any contracts or agreements or other arrangements between the dissolved agency and private parties should be terminated or renegotiated. There is an item on your agenda that is specific to that, and that is to reduce liabilities, to determine whether it reduces liabilities or increases net revenues to the taxing entities. And then that proposed termination or amendment would be presented for further review. And then it says the board may approve any amendments to or early termination. I think that goes to your question of those agreements where it finds the amendments or early termination would be in the best interest of the taxing entity. So it is a findings process, and it is a fact-driven process as it pertains to those existing agreements, vis-a-vis whether they should be terminated or renegotiated.
It's a good point to make. It is a process which requires some due process, which the board has to make findings in accordance with the statute. But termination of a contract is within your power if those findings can be made.
But there is some due process for those folks, the third party with which the agreement exists. It isn't as though there is, again, as I say, there's an overriding veto power from this board over those existing agreements. If we
there really isn't that much due process in this process for the third parties, unfortunately, which is one of the defects of this whole structure, which is...
And I'm sorry, but one of the reason why I asked the question, I'd seen a news item that there is I believe it's either an insurance company or an investment bank that is filing suit with the state of California.
Right. Syncora, which is a company that insures municipal bonds, has already filed an action with the state of California, and they are claiming that AB 1X26 was illegal because it interfered with their ability to contract and cause them damage. And they point to the fact that immediately after the adoption of the statute, $11 billion worth of California redevelopment bonds were reduced to junk status. So that action has just been filed. It is, in my view, a very key action because it's the first case that I'm aware of that has been brought by a third party. So far, all the litigation in the system has been between cities or counties and the state. So that is a very key case, and it'll be interesting to see what happens with it, because interference with contract, I think, is a pretty strong argument, and it's pretty clear that there's, as currently written, there's a lot of power granted to the DOF, and even down to this level, to interfere with contracts.
So that being said, if there was the decision by this board to undo an existing agreement that granted land use rights by the City of Glendale to a third party, that third party does have some recourse as to a tangible material loss.
Yes, not so much through our process, but through an independent action, yes. The Syncora case is also alleging inverse condemnation. So it's going to be quite an interesting case, and I wouldn't be surprised if it's not followed by a number of other third-party cases from bond insurers or bond underwriters, bond purchasers, people who've been affected by the diminution in the value of redevelopment bonds.
And has there been any indication of the timing that this litigation would start to unfold?
Well, it was filed in the Superior Court, so it has to work its way through the appellate process. It probably can gain some priority in the legal system through a couple of means, but it will still have to have an order or a judgment to appeal to the appellate court, and then from there to the Supreme Court, unless the Supreme Court issues a ruling prior to that on one of the state, city/county cases that makes it moot.
Thank you.
Mr. Chairman, I wanted to emphasize the point that I think Mr. Ochoa is starting to make. While you have the ability to terminate contracts, all of those termination provisions still exist. So if you said cancel that, whatever damage was available or whatever remedy was available in terms of damages, we would still be responsible for, we being the successor agency. So while you can, there are consequences to doing that. And while there, and I think this was Mr. Green's point, while it may not be an action against the state or the oversight board or anything else, there certainly would be something against the successor agency to ask for those damages. Yes,
if I may, the section which Council referred to earlier, which is 34181E, it provides the power to determine whether contracts, et cetera, I'm going to just should be terminated or renegotiated to reduce liabilities and increase net revenues and so on. And it says the board may approve any amendments to or early termination of those agreements if it finds that amendments or early termination would be in the best interests of the taxing entities. It's pretty clear to me that the best interests of the taxing entities has to, in addition to the factors inside the deal, has to take into account potential actions outside the deal, such as lawsuits by affected third parties whose contractual rights have been abridged. And clearly, adverse conclusions in those lawsuits would affect the ultimate amounts recovered by the affected taxing entities. So it is only prudent to take them into account in your considerations.
And in your, as you look at this, is there a bright shining line in your mind between enforceable obligations and non-enforceable obligations as to whether or not there are third parties that have a stake and have a claim for damages, a realistic claim?
I guess I'll repeat one of the things that I said when we were interviewed by the subpanel of this body, which the question of our experience in AB 26 came up, and what I said to them in all candor was that anybody who sits in this room and tells you they completely understand exactly what AB 26 does is selling you a bill of goods, because it changes on a daily basis sometimes. And now with 1484, it's even more complicated. There's not a bright line in almost anything in this law. Certainly the determination of enforceable and unenforceable is going to call for a legal judgment. And some of them may be clearly to somebody experienced in the matter unenforceable. Others may be clearly enforceable. But there will be a lot which may fall into the middle area where there's certain contingencies that have to happen before something happens, and therefore, is it truly enforceable? If in those, it becomes a game of making the best call that can be made under the circumstances, given all of the facts before you. So
at that time, because
without any guarantee
that
it won't change
changes
before the next meeting. So it's an exciting. There's no Irish curse, which is "May you live in exciting times," and I think we all must have been cursed by the same people, because this is certainly exciting times in California and redevelopment.
Mr. Chair, just to follow up with what Mr. Ochoa said, which is the reason that we have legal counsel in the first place in 2 months or 3 months ago, was because we really weren't sure what we are doing. I've watched probably, 8 different slides and watched about 4 different videos, and I've read this section probably more than 10 times, really I have. And maybe we need to have redevelopment dissolution for dummies handbook, but it is extremely complicated. And what the reason when we actually ask for legal counsel, the reason that I really need legal counsel is to tell us what is the authority of the redevelopment dissolution committee, what things we can do and what things we can't do. That's something that has never been clear to me, right. Because on a weekly basis, and Mr. Ochoa said, Albert, it doesn't matter, just let's approve it and they'll come back to us anyways, and somebody else says something different. So as our attorney, we need at least a roadmap as to the things that we have authority on. And I don't know if we can say things we don't have authority on, just the things that we do have authority on. So this way, then we are all very clear as to what we're doing. Our legal counsel said we can do the following at least pretty safely, and then other things that come in, we can take it as we go. But to go through this road blocks as we have gone and not have a good idea as to what our authority is, it is just unbelievable. So.
Well, our goal here will be to make it as clear as it can be,
right.
What your rights and obligations are, and in the cases where we can't make it clear, to explain to you that we can't and why.
Can we get a memo from you guys? I don't know what the budget is for the legal department, but this is probably the most important thing that you guys could do for us, besides being here and giving us advice, is
Certainly.
to give us a roadmap as to what things we have authority on. I mean, that would be my request from the legal counsel, to tell us what things we can do, so when we come back next time, we have that roadmap. There's no one that's telling us, "Wait, that's not in your authority, forget it."
If that is this board's desire, we certainly can do that.
Well, I know as chair, I would like that too, but I also know that this is something that is going to be a constant change, and that means that you're going to be in some process.
And we'll attempt to update it as we go along. So,
yeah, because just since we met for the first time, we've been inundated with changes in legislation. Mm-hmm. And the result is that you always question your actions as a result of that, because your feet aren't sure with respect to the ground.
Just so it's clear to my firm, which incidentally, Green, D. Bortnowski, and Quintanilla is often difficult for people to remember or say. So most of our clients refer to us as GDQ because it's easier. So feel free to do that if you wish. But we will
Well, I think
always
it's
try.
the wish of the board. I see a lot of nodding this way instead of this
Okay.
way.
In the absence of objection, then that's what we'll do.
All right.
Thank you.
All right, let's go on to the next item.
At 3C is Oversight Board proposed meeting schedule.
We took a look at AB 1484 and all of the new requirements and specifically new deadlines coming up between now and spring of 2013 and attempted to match up your regular first Wednesday of the month meetings with some of those dates. Unfortunately, they didn't all line up neatly, and so your exhibit shows in bold are the special meetings, and in regular font are your regularly scheduled meetings to take place the first Wednesday of the month. We don't need an action item on this. We just wanted you to calendar these dates because we will need to call some special board meetings in order for you to review some items that are specifically contained in AB 1484. I will add, though, one of the first items after ROPS 3 is the due diligence review, which is the audit of our funds. The state has not yet provided clear guidelines to CPA firms in order for us to contract with a CPA firm to perform this audit. The guidelines are expected sometime at the end of this month, so it is possible that some of these dates may get pushed back. However, without knowing when those guidelines were going to come out and knowing how busy you folks are, we wanted to list out all of the meeting dates so that they're on your calendar, and if we need to shift, we will shift, but the penalties are too stiff for us not to get you together to act on these items.
Thank you. Next item.
At 4 is Director of Community Development regarding Successor Agency determination regarding the termination or renegotiation of private party agreements, contracts, or other agreements. At 4A1 is resolution directing Successor Agency to renegotiate the agreement between the former Glendale Redevelopment Agency, GRA, and Wilson Maryland Lofts, LLC, for the Lemley Lofts project. At 4A2 is resolution directing Successor Agency not to terminate or renegotiate certain contracts, agreements, or other arrangements between the GRA and private parties.
Chair and board members, this item dovetails to the discussion just a few minutes ago with our law firm. At your first meeting in May, you directed us as part of ABX 126, specifically Section 34181E, to look at all of our agreements and contracts and determine if any of them can be terminated with the goal of freeing up that money to be distributed to the taxing entities. We have done that, and we have brought back to you resolutions today. For the most part, we did not find that we could terminate or renegotiate any of the contracts without either breaching or without penalties, and so our recommendation was to not renegotiate or open any of the, not to terminate any of the contracts with the exception of one, which we'll get to, which is the Lemley Lofts project. Before we get to that, I do want to submit as part of the record, two of the agreements that we did look at are the Alex Theater lease and management agreement. These were agreements that were entered into back in 2008, and the agency looked at terminating those contracts and determined it was not in the best interest of the agency to do so. We have received, as part of the record, and I do want to submit this to the clerk, 19 letters of support, and I do have them. I'd be happy to hand them out before I hand them over to the clerk, which all are asking for this board's support to not terminate the Alex Theater lease and management agreement. Additionally, out in the audience, there's over 20 people that I count that are here for support of the Alex Theater. So I would like to submit these into the record, and we can take any questions if you'd like, but I did want to point this out because we did receive these letters of support. If there are no questions, I'll hand these letters out for you to review and submit to the clerk, and then I will go on to...
Well, before we do that, one question is that the letter writers have had a chance to review what the proposed action is today?
Yes, correct. Most of the...
You're saying the letters are in accord with respect to the proposed action?
Correct. They support staff's recommendation not to reopen and not to terminate the lease and management agreement with Glendale Arts, the operator of the Alex Theater, and the redevelopment agency.
All right. Thank you. Questions by the board?
About all of them, or just that Alex Theater issue?
I think we're presently on A1 at the present time.
Then if there aren't any questions, the one agreement that we do want to renegotiate or reopen up is the Lemley Lofts agreement, and for that part of the presentation, I'll pass it on to Philip Land.
Before we get that, I think there's another issue with Museum of Neon Arts, number 2.
We also reviewed that agreement, and we determined it was not in the best interest. So if there are any specific questions, we'd be happy to take them. I just wanted to call out the Alex Theater because we did receive the letters of support.
Why do you think that there is no? Why do you think it was not in the best determination?
I'll turn it over to Ms. Van Meiden to answer that. She'll do a better job.
Thank you. Excuse me. Thank you, Ms. Babolian. Mr. Chair, members of the Oversight Board. The Museum of Modern Art, or MONA, is currently in a ground lease with the Glendale Redevelopment Agency. And that ground lease, which is an existing enforceable obligation that has been approved on the prior ROPS, is listed on ROPS 3 that you'll be reviewing shortly. MONA is a private nonprofit corporation, and so one of the components of our examination was whether or not that nonprofit could afford to deliver more money into the deal in order to reduce the agency's current obligation under that lease agreement, and that obligation involves in yielding a core and shell of a building that for which they will take over the tenant improvements, and then after a period of time, once their museum is established, which is across the street from the existing Americana at Brand commercial mixed-use project and the Central Park and Central Library. And it's intended to open out onto a paseo that will join these two areas together. So the expectation is that this site will draw a significant amount of pedestrian traffic and create an interconnection that will activate that area. And that expectation will lead to their ability to have more clientele and therefore earn more money through their activities and pay the rent structure which increases over time. So it was an opportunity for them to move forward, but initially they don't have the capability to put more money into this deal to reduce the obligation. And as was previously indicated, one of the components of the Oversight Board's examination is whether or not the termination or renegotiation of that agreement might create additional liability to the taxing entities. And we are in an existing contract with them. Whether or not they would choose to pursue legal action against the agency for early breach of that agreement is yet to be known, but certainly that is within their power under the agreement to do so. So under those circumstances and looking at the capability of the private party, which is a private nonprofit corporation, looking at the potential exposure of the former agency that is the landlord under this deal, and also looking at the potential under this agreement moving forward once the building is constructed and MONA is operating, that it being potentially more lucrative in terms of overflow or secondary benefits in increasing improvement of areas surrounding that site, it is ultimately, in the longer range view, of more benefit to all of the taxing entities in that it'll improve property values in the area. So those were some of the factors that we took into consideration during our analysis of this particular ground lease. I'm available to answer any additional questions.
Other questions?
I do have some questions on that. Thank you. I mean, I can't believe that we were talking about Alex Theater lease and management agreement, and even having it here, and then Mona is something that we're not even discussing. I think that it is complete waste of money for the city of Glendale and time. We haven't put $1 in reference to the soccer fields, let's say, that services 4,000 kids in our city, and we're actually thinking about and discussing money for Museum of Neon Art. I mean, it just baffles me. So for that, I would like to know on this Mona. I would not like to approve it personally myself. I would like to know when is the time, how long of a contract we have, when we can actually terminate this, and then divert the money to Alex Theater lease or do something else. But to do something like this is just unbelievable. I just can't even believe that we're even talking about a Museum of Neon Art in this city. And I've been a taxpayer for 30 years in here, so I'm actually offended that we would put money towards this and not put money towards something else. Now, I would like to know, based on our authority, when is the contract going to be over? How long of a contract do they have? What could we do to actually terminate this particular agreement?
And just to add on to that, if we were to terminate it, and and again, it goes back to that first question I had, and I think it shares with Mr. Abkarian, can we, quote unquote, the Oversight Board, terminate this agreement? Do we have that authority? And if we do, and there is liability, who suffers that liability? We, the Oversight Board? We, the Successor Agency? We, the City of Glendale? We who?
I'm going to pass the ball over to your Oversight Board counsel on that question.
Well, thank you so much.
You're so welcome.
I can see we're going to be good friends. The understanding at this point in time is that the Oversight Board would not have liability because it would not be in contract with the underlying party. The party that would have the liability would be the Successor Agency. Now, bearing in mind that the Successor Agency is the owner of assets which are to be liquidated ultimately for the benefit of the taxing entities, it kind of comes to the same place. The board doesn't have the direct liability, but the money's still at stake. If there is a defense to be provided under a contract, and this board directs that it be terminated, and the third party has a right to sue the Successor Agency, it can recover against that agency, and then its assets would be liable for the payment of that judgment. Those assets would thereby be diminished, leading to lower disbursements to the affected taxing entities. So, do you get sued? No. Is there a cost to you? Absolutely.
To you who? To you, the Oversight Board, or you, the City of Glendale?
To the taxing entities that this board has a fiduciary responsibility to.
Let me just ask one more question. If the Museum of Neon Art's contract is terminated, and there are no legal action against us, then the funds that are basically set aside for Mona, so to speak, would that go back to be divided to other, hold on, let me just, I know everyone's shaking their hands, I don't even know what I'm going to say. Is the money, could the money be allocated to another project within the redevelopment agency, or does that go to be divided between the taxing agencies?
Well, it's most likely going to go to be divided between the taxing agencies.
They can't be diverted to another project within the redevelopment?
It certainly, unfortunately, cannot be diverted to soccer fields because that's not within the purview of the Successor Agency unless...
Or any other project within
at least unless the agency owns that. But typically what would happen is each of these deals would be looked on by themselves. They'll either stand or fall by themselves. That's the way the DOF is going to look at it, so that's the way we should look at it. And if in fact they do not have a right to sue, or we took the chance and they decided not to sue, then any money thereby saved would revert back to the fund, which would then be dispersed.
To the outside of Glendale to different taxing agencies.
Does that answer the question?
Yeah.
All right.
Not the way you wanted to, probably.
No, it was. I mean, I appreciate the answer. It's not what I thought we could do. So this is the reason I need you to provide a memo.
And just to be really clear, just to punctuate that point, we, again, as an oversight board, are overseeing the actions of another body, as opposed to unilaterally making policy on our own.
No, you're making policy on your own because you have discretion to take action here. Anytime you have discretion, you have policy decisions to make.
Discretion without any substantive repercussion, because the repercussions accrue back to the agency and ultimately the taxing entities, as opposed to this group as...
This board's function, primarily cut down to the simple roots, is to represent the taxing agencies who are to receive the money that is derived from the liquidation of the assets of the former redevelopment agency. You have a fiduciary responsibility to those affected taxing agencies to take actions in a responsible manner which are to maximize the return to the affected taxing agencies. Sometimes you're going to have difficult decisions to make. Is less money now better than more money later? You know, those kinds of decisions. And those are going to be policy decisions that you will make based upon facts that you have before you. Well, I guess we could argue about whether they're policy decisions since they're specific to a particular transaction. But yes, you have a lot of ability because of the language which we read earlier about making findings. You can modify, amend, terminate, and so on. So you have a great deal of authority.
But I guess maybe more specific to my point is that if this group said no to Mona, don't want to do that, it gets rejected. And it happens almost in a vacuum because the successor agency still has a role to play. It isn't as though as we are usurping the successor agency any more than the successor agency can usurp us.
Well, you're usurping them in that you're limiting their actions.
But theoretically, theoretically, nothing would happen. If we said no to Mona and the successor agency came back and said no, yes to Mona, and we said no to Mona and ultimately some time threshold passes, that money just goes to the taxing entities.
Yes, eventually it's going to go to the taxing entities.
My understanding is if we say no to Mona, I mean, the successor agency can't say yes to Mona at that point.
Well, no, the law does not contemplate that. That doesn't mean that sometimes it might not occur in California. I mean, there's certain cities that are refusing to turn over money and so on. But the law provides that the successor agency has to do with its assets as you direct.
Mr. Sheenan had a question.
Now, would we have the ability, because I believe it's a 5-year lease?
If I may, it's a 15-year lease with 3 options to extend. It commences on delivery of the premises by the landlord, which is the agency, and that is after the completion of the landlord's work contemplated under the lease, which is, in effect, to render the building ready for the tenant improvements to commence. So it's a 15-year lease with 3 options, 5-year options to extend.
If I may make a recommendation, I view part of our role here as being able to look at specific transactions that you're entertaining, taking an action with respect to, and giving you a view of what we believe the legal obligations are and what the ability to terminate it is. It goes into our factoring in risk factors because if it's an absolute certain thing that they have remedies, and some agreements even have dollar amount penalties written into them, then that is something that you should know and we should be able to put on the table for you. We have not reviewed this agreement, know nothing about it whatsoever. I don't know how enforceable it is. I don't know what the rights to terminate are. I don't know what the penalties are on termination. So I would recommend that you not take any action on a contract like that in that kind of a absence of facts. If it's contemplated that a contract is to be terminated, then I would recommend that it specifically be placed on the agenda, that we be provided an opportunity to look at it, and that we write a staff report to you that says, here's what we see the risk factors being associated with this are: low, medium, high, none. And on occasion, we think this is your job to do, but on occasion, because of certain factors, we may make strong recommendations. But usually what we'll do is we'll just outline the risk factors for you, and you make those decisions.
But as I understand it today, the only issue is Mona.
That's the only issue that I have.
And
well, there's another matter on the calendar for an amendment, I think. But
I just don't want to lump them into one because I don't have any problems with the Alex Theater.
But regarding the action item of A1, 4A1,
I was looking at 4A1 though. All of that is under 4A1. My understanding is 4A1 includes
the
four
board
items.
is in
right?
also a difficult position, and I'm not recommending that anything be done about this, but I think it's my duty to bring it to your attention, which is that it's in essence the successor agency is making the determination of what matters to bring before you for termination and so on. Probably given the volume of all of that, I doubt if there's a reasonable, cost-effective alternative. But I do think it's only balanced to remind you that the successor agency is the one that's going to get sued, and so they have, and also the successor agency may have particular feelings about particular projects and their need for the community and so on. I know that I would if I were in that position. I spent most of my practice life representing redevelopment agencies, so I totally get that. But I think you have a great staff that's working with you here, but just remember that they're not working for you. They're working for the successor agency, which may have its own needs. So we only kind of came up with this modification of the theater because Mr. Carrion raised it. It wasn't put on the agenda for action. So it kind of leads to you to understand that there may be things that this board might want to look at least, that are not coming up.
Mr. Sheehan?
So is it possible to amend this to pull them out individually?
If I may offer, if the board directed us to remove the Mona agreement and follow staff's recommendation to not reopen and not terminate the other agreements, a problem that I foresee is that would direct us to remove the Mona funding from our ROPS. And because we have to act on the ROPS and send it over to the Department of Finance by September 1st, I see a timing issue because we would have to quickly bring back this Mona analysis from GDQ back to you by next week in order for you to determine whether we continue with the agreement and put it on the ROPS, or we don't continue with the agreement and it's removed from the ROPS. So I see that as an issue. If they commit to doing that analysis and bringing it back to you next week, I think we will certainly do what we need to do to get it on your agenda for next week.
Just as a matter of practice, I think that we should get more information about some of these items. If we're going to actually accept them or reject them, then we should have some more information than the 3 paragraphs we sometimes have here. Maybe even have an agreement attached to it so we can look at some of the subparts. We need to have more information. I mean, what do we do now? If we take them out, without having all the information, then it's out of the ROPS and it doesn't come. If we don't take it out, then I'm going against what I want to do. So whatever you guys want to do, but we need to be given more information than a paragraph or two about some of these agreements if we're actually going to make an intelligent decision.
Understanding and respecting that point, but at the same time, the Mona deal, as an example, has come before the public in the form of the Glendale Redevelopment Agency many times. Most recently, when it came before the Successor Agency with full documentation. So, I mean, to the extent that it is vetted, and to Mr. Green's point, it is something that the local agency that I represent certainly has wanted to move forward on. It exists as a priority. That's why it's on this sheet. And that's something that the community has been engaged in, something that the community has vetted.
I don't see a problem legally in you accepting their recommendation. I see a problem if you decide to pull something and terminate it, is where I would want you to have an opportunity for us to look at it and so on, because that's where risk factors start to develop.
Is pulling it, though, Mr. Green, to that point, missing the ROPS, losing it off of the ROPS forever, this, akin to a pocket veto. It goes off and you'll never see it again. The loss is realized, the liability incurred.
If that's what were to happen, I think the point has been made that you have until your next meeting to make a final decision on those. And certainly, if you don't want to cancel that transaction, then don't take any further action on it and approve what they've asked you to approve. If there is a feeling that it should be terminated, then I have to strongly recommend that you not terminate it until we've had a chance to look at it. And we certainly would do that and come back with a staff report by your next meeting. No problem.
Mr. Chair and members of the board, if I might just add to that the failure of the successor agency to submit the ROPS to the Department of Finance by September 1st has extremely harsh penalties attached to it, which include $10,000 a day. And if that delay passes 10 days, it would include on top of that a 25% reduction in the administrative cost allowance to the successor agency. So we are very interested in fulfilling the needs of the Oversight Board to complete this process as timely as possible.
Well,
Mr. Chair, if I could, Mr. Green's point is well taken. If there is a desire by the majority of this board to not terminate, nothing more need to be done. The question that I would have is, could you pull it out, not consider it, leave it on the ROPS, and then come back at a later date to examine it, and if you want to terminate then? Certainly would be before any funds were spent.
I would think that would be a very reasonable procedure to follow. It's just not clear that that's permitted. That's, I mean, I would have to say, and for the safety of the successor agency, it seems to me that you should either decide at this time not to terminate it, let it go on the ROPS, because it's not clear. See, ROPS is really a financial issue, and the section that gives you authority is not related to that per se. So it's certainly not the case that you can look at this law and say, if you put it on a ROPS, you cannot later terminate it. I believe that you have that ability at any time a fact comes before you that you think drives a need to terminate an agreement, even if it's been on every ROPS you've ever filed. So rather than take the risks or have to have a special meeting over one transaction, even if the majority of the board is concerned about canceling it, probably I would recommend that you just indicate to staff that they should go ahead and put it on the ROPS for this time, because, as they say, the penalties are phenomenal. And then take your time to do a review and undertake to do the termination at that time if you feel, after the review, that the findings can be made.
Is that agreeable to the board? Do I see nods?
Mr. Chair, so just so I can understand, so if we go forward with with these items today, then we could have Mr. Green do an analysis and come back with the risk analysis, I guess, on if we were to terminate these, and we could still do that at a later date. Is that?
The analysis would be in particular associated with Mona.
Yes.
All right.
I mean, that's the only one I've heard any question about. I don't think you want to pay us to go through every deal that the Glendale RDA has ever done. I don't particularly want to do it either.
I have several speakers for the subject. And I think in the interest of time, I'm going to limit it to 3 minutes, if I might, for each speaker.
Mr. Chair, if I can allow Mr. Lanzafame to go over item number 2 before we take the speaker cards and may answer some questions.
Mr. Lanson.
Mr. Chair, members of the board, as Ms. Babolian said, for the most part, staff is recommending that we don't terminate or we don't open or amend any contracts. There is one, though, that we are recommending an amendment to, and that is the Lemley Lofts project. In March of 2011, the redevelopment agency entered into an agreement with Lemley Lofts to build a Lemley Theater, 10,000 square feet of commercial space and 42 apartment units above. Under the original scope of development, parking for that project was to be provided in an off-site garage owned by the City of Glendale. After some examination of the market and its viability in the marketplace, the decision was made by both the developer and the redevelopment agency to amend that scope and include underground parking. The cost of that, the additional cost of that parking was to be split equally between the redevelopment agency and the developer. That proposal was memorialized in an agreement. It was adopted and approved by the redevelopment agency in November of 2011, subject to the decision in the Matasanos case. As we know now, the Supreme Court ruled, for all intents and purposes, against redevelopment and eliminating it, which rendered that agreement null, that second part null and void. What we're asking today is that the Oversight Board authorize that same proposal to add dollars to the project, which will create what we believe a better situation for all the taxing agencies. If we can bring up the chart, you have an Exhibit 1, a chart. What we did is an examination, analysis of pros and cons of doing this, and we looked at if we were to just not do the project, so we would have $2.6 million of, here it is, this is Exhibit 1 in your packet. If we did not do the project, go up just a little bit, Michael. At the very top, and we're calling it gross tax and entity cost. This is really what we refer to as an opportunity cost. There's $2.6 million that is invested in the project that, if it were not to be invested, would be available for split among the taxing entities. The property is worth about $1 million, giving us a total of $3.633 million. If we did not do the project, that's the amount of money that would be available, let's say, for distribution to all the taxing entities. That's assuming that there's enough other property tax to pay all of the agency's obligations, which, by the way, hasn't happened yet, but for sake of this analysis, we're assuming that it does. If we build the project, we looked at the revenue that would be generated from it, and you see the different categories of property tax, sales tax, impact fees to the school district, and then city fees. It has a net benefit, the project, if you build it, of $263,000. So we believe that we meet one of the tests, that there is a net increase in revenue. However, we go down to Table 2, and we broke it out amongst the taxing agencies. If we were just looking at this from the city's point of view, thumbs up, way to go. But as you can see by the black and red numbers, the city comes out ahead on this deal. If we build it, all of the other taxing entities come up short. What we proposed to the county, and we've begun some preliminary discussions with the county and county staff, is tax sharing agreements with them, whereby the city would make them, at minimum, revenue neutral on all of the increment or revenue that they would receive. In addition to that, there would be several non-financial benefits, namely the elimination of blight and the revitalization of an important piece of property. Probably the most important non-financial, although it does have some financial benefits, is that we were going to build this project with the Alex Theater. And Michael, if we can have one of those, you can just, hang on to that. We've also put together a site plan. If you can see here, I don't have a pointer, but if you can see here, the Alex Theater is on the right. The gray box is the Lemley project. That space in the middle is to be shared between them for access, for loading. Thank you. This space in here will be shared for access. The theater will be able to modify their loading, which is important to them for their viability going into the future. And it's important to note, this is, while it's in the city of Glendale and is one of our icons, it is a regional performing arts center that was developed. So we believe it's an important asset to keep. It allows them to load here, which frees up this space in here. Because right now, the theater loads like this in a very inefficient manner. If you can go to the site plan. Here's an aerial, the Alex Theater, and then down here is where the Lemley Theater would go, the Lemley project. We hope to excavate this entire area all at once. Now that gives us an economy of scale and reduces the cost. So if we're not able to do one of these projects without the other, costs go up. The second thing that it does when we do it together, it provides that we close the Alex Theater down only one time. If we do either one before the other, we wind up having to close the Alex Theater twice. And the executive director of Glendale Arts is here. She can tell you the potential of losing the Alex Theater completely if we're not able to keep it open. As it is, we would plan to close this during the summer months when it's a low period for the theater, and then we think, given the new amenity, that we can rebound. Again, doing both of the projects together is critically important to be able to achieve that. Some other important benefits, again, we're calling them non-financial, but they translate into financial, is job creation. That is one of the things that the state of California right now is looking at. How do we replace those jobs that were being created by redevelopment? I think the legislature is starting to understand that issue and looking for solutions. We believe, as our counterparts in the county, I think we're both nodding our heads, I won't speak for them, but we believe that this becomes a model for future revitalization efforts and economic development efforts, which we all know are important to all of our entities. And then finally, the theater project provides some what we'll call transportation benefits. We do put 42 units in close proximity to employment centers, so we're hoping that people will leave their cars at home. It also has amenities to promote bicycling and bike lockers. There is the commitment by the developer to participate in a shared car arrangement where they would have a car that was available for all 42 tenants that they could check out. We're also talking to other urban developers in Glendale. Would they provide the same? So we start to create a network whereby we're reducing the number of cars that are in Glendale. Finally, they'll have a charging station for electric vehicles in this. Now, we understand that it doesn't fit perfectly within 1484. We do think, though, that it is within the spirit of the law that you're able to do this, looking at the analysis that we have. We keep everyone revenue neutral, and we create some additional benefits. However, The way that we need to structure this in our ROPS is what you have before you, and I'm getting a little bit into our next item on the ROPS, but so that you're aware of what we propose. We would like to list the additional $1.1 million. We already know the first agreement and the 1.5. It's an enforceable obligation. It's been recognized by the Department of Finance as such. We would like to have your approval to renegotiate that agreement and tax sharing agreements with the other taxing entities to keep them revenue neutral. We have included the entire amount on our ROPS 3, which you'll be looking at in our next item. That's because we will need to commit, if we're all in agreement, all the taxing entities, we will need to commit that $2.6 million in this ROPS period. That is, we're doing that January to July. We'll need to commit it then. So we're asking you to conditionally approve this line item on the ROPS. And the condition would be that we enter into tax sharing agreements with all the other taxing entities to keep them revenue neutral. Again, we did the analysis for over 30 years, and what we would propose to do is share that revenue. We would most likely look at the delta. What was, for instance, I think the school was $25,000. We write a check for $25,000, and then they continue to collect their increment just like they normally would. We believe that that's a clean way to do it. It's straightforward. Nobody has to monitor over years' time. And again, we think this is a model of how the cities and the other taxing entities can work together in the future to continue positive economic development. We don't see a downside to it because the Department of Finance will ultimately take a look at it, and we believe that if we have the other taxing entities in agreement, there's no reason why they should turn it down. If the other taxing entities are not in agreement, then we don't do the project. With that, I will ask if you have any questions.
Questions of Mr. Lanza-Fane? Thank you. I think it's appropriate to go to speakers now. Yes. And there are several cards here. 3 minutes. Please, Mr. Wilkie.
Thank you, Chairman Raggio. I'm Jim Wilkie. I'm a Glendale resident, and I'm also chairman of the board of Glendale Arts. I want to thank you, first of all, for taking the time to sit on this board. I'm glad you have counsel. I got lost about 17 times listening to the discussions, so I apologize for that. But beyond that, I also want to thank the many members of the community and the current Glendale board members, our advisory board members that are here in support of the Alex Theater and Glendale Arts. As you know, Glendale Arts has been instrumental in bringing cultural events to the theater and in bringing vitality to downtown Glendale. So we're a strong supporter. We stand behind everything that Glendale Arts represents, and we're looking forward to continuing that into the future. I'll let it go at that.
Well,
keep it short for you, sir.
Thank you. Ms. Elisa Glickman, please.
Mr. Wilkie's a little taller. Chair Raggio, members of the Oversight Board, I'm Elisa Glickman. I'm the CEO of Glendale Arts, which is the management company of the Alex Theater. And I'm here not only representing myself and my staff, but also the many citizens and supporters of the historic venue that Ms. Babolian mentioned earlier, as well as all of the phone calls and emails that I've received personally over the last several weeks talking about the importance of the Alex Theater. And I'm asking you to unanimously support the enforceable obligations set forth in the management and lease agreements that you're discussing today. When both documents were negotiated, it was understood by the former redevelopment agency that these capital improvement projects and expansion plans were critical to ensuring that the Alex Theater remained competitive in the marketplace, a marketplace in the Los Angeles area that is incredibly crowded with a tremendous amount of competition. Many of our competitors have some of these amenities that you'll be deciding and addressing here today. I also wanted to add that some of these plans were in the original construction and restoration of the Alex when it was purchased in the early 90s and were tabled to be addressed down the line. Knowing that the redevelopment agency for the downtown corridor was set to expire in 2015, the former agency put those projects in our management and lease agreement to ensure that they would be completed under the purview of the redevelopment agency so that, again, we could remain competitive and go towards that road to self-sufficiency that has been so important. So many of the elements that we're talking about here today, such as capital improvement projects, some of those items were purchased 20 years ago, and they have a shelf life of about 20 years. Our staff and our crew has done a phenomenal job kind of MacGyvering all the pieces together so that they maintain their workability, such as boilers and air conditioners and all those sort of sexy things that we all take for granted and keep things going. But at some point, all of the quick fixes that we're making won't do us much good, and we're definitely going to need to replace those. And they're costly projects, as many of you know. So it's our hope and our expectation that you will take the staff's recommendations here today and ensure that we will be able to continue on that path to self-sufficiency and continue to manage the venue as the resource, as the arts and entertainment center that we've all come to love and appreciate. And I thank you very much for taking the time to not only listen to our remarks, but also to participate on this very important board.
Thank you.
Thank you.
Mr. Barry Allen.
Thank you, Thank you, Mr. Chair. After listening to Mr. Lanzafame's rousing conversation, I think one of the things he missed was that $263,000 is something about $8,000 a year for the next 30 years. Now, certainly, we're making at least that much off of the parking lot and off of the Panda Inn and it's the money that it generates, the sales tax money. With regard to Mona, one of the things that had come up on many occasions, and I heard one of your members, I believe Mr. Abkarian, bring it up today, is that looking at their financials that the city refused to provide us, their financials showed that they're really not a viable institution. And any money that you're going to throw at them is ultimately going to be wasted. They've already been proven to be a financial burden. I also want to just touch a base on the Lamley lofts. Now, I would think that this council should definitely review pages 470 to 474 and 603 to 605 of the Draymond grand jury transcripts, wherein Mr. Nathanson, the principal of Mapleton Construction, or Development, made sure that Mr. Draymond, who at the time was a city council member and on the redevelopment agency, that he received $100,000 to pay bills. And I think that certainly does question the viability and the perception of that project going forward. And I think it's certainly something that this oversight committee should do. You shouldn't just be a rubber stamp. You should say, terminate. You have that right to do so under the AB 1484. And I'm not going to go into the Alex Theater, but that when it comes about, it's also going to reduce parking. And I think you'll find every one of these projects, from the Marriott to Lamley to Mona to the Alex Theater, is reducing parking, public parking, and is not providing anything to do it. Other speakers, I think, will address the actual parking issues that are so involved. And I know we're pressed for time, and I will thank you very much. I'm Barry Allen. I will leave a copy of this with the clerk.
Thank you, Mr. Allen. Mr. Kenneth Landon.
Thank you, Mr. Chairman. The Glendale City Council, also known as the GSA, successor to the GRA, does not recommend terminating 4 projects. The Courtyard by Marriott, 11-story, 580 580 parking spaces was in the original agreement, reduced to 39 parking spaces. The Lamley Lofts has only 44 parking spaces, yet they have 42 units, and they have 5 theaters, 2 restaurants, 6,000 square feet of commercial stores. So they provided no parking for any of the commercial. We have the Alex Theater. Any expansion would cut into their existing parking space, reducing parking. And then the Mona Theaters have no parking spaces. All 4 of these projects are in the Downtown Specific Plan, the DSP. Now, under the Glendale Municipal Code, Chapter 3032, Parking and Loading, .02 applicability, the GRA or the GSA may, upon application, grant exceptions to the minimum number of required parking spaces or parking standards if the GRA finds that, 1, the parking spaces required for the proposed use cannot reasonably be provided by the provisions of the title without impairment of the project's viability. Number 2, the parking exception would be consistent with the various elements of the general plan and promote the general welfare and economic well-being of the area. And 3, the project involves exceptional circumstances that do not apply generally to other properties in the area. And lastly, number 4, there are mitigating circumstances whereby the exception will not be materially detrimental to the public welfare or injurious to the property improvement in the vicinity of the property in the neighborhood in which the property is located. All 4 of these items are required for the GSA to grant an exception to the minimum number of required parking spaces. There's been no environmental study, and also under the reduction of parking requirements, the community development may require a parking demand study prepared by a licensed traffic engineer or other traffic professional. The GRA or the GSA, which is the successor, may grant exceptions to the minimum number of required parking spaces and standards under pursuant to 3032.02 for only projects in the redevelopment area except if partially or entirely located in the DSP zone. These 4 projects are in the DSP zone.
Your time is up.
So I only have one last thing. I hope that this board will not rubber stamp these 4 projects that provide less than the minimum required parking spaces that are required. And again, the DS.
Thank you, Mr.
Thank you.
Mr. Chair, may I make just one comment before we go to the next speaker? I'm hearing these things, and we are not city council. We're not elected to this office.
We're
to act.
neither the successor agency either.
We are not. So, I understand his comments, and there's constitutional right to come in here and discuss these comments in front of the city, in front of this board, and it's appreciated. But we're not elected members. We don't have any authority to do what you're asking us to do. I mean, I might question a few things, but I understand what my limits are. My limit is that I'm not a city council. I'm not elected to office to do this. I'm not the successor agency that has the obligation to do these things. Our job is to protect the taxpaying entities, to ensure that the taxpaying entities will get what they should be getting under the ROPS. That's what our limitation is until next time when we're told what we really can and can't do, which is my understanding. Parking issues in reference to how big the project should be, issues having to do with what they should do. There is a body that could address that, which is the City Council, the Successor Agency, or direct communication with the city. It's not us. We are not going to now come and sit. I apologize. I shouldn't say we. I am not going to sit here and second-guess the City Council's decision or the Successor Agency's decision, or do I have the right to? So I just wanted to make that very clear, because I've noticed that in the past 2 or 3 times we have people are coming to us telling us things that we have no control over whatsoever, which is in the jurisdiction of either city council or successor agency.
I think as time goes on, there may be more of a clarification of our role,
Right.
but I think right now...
I just wanted to mention that, just to clarify that particular issue, just so there are no confusions as to what we can't do. We're not a replacement for the agencies that have the authority or the entities that have the authority to do this.
My next speaker is Mrs. Coates.
Thank you, Mr. Chair, members of the board. My name is Shahida Coates. I'm an attorney with the Los Angeles County Council, and I'm here to speak with you in respect to the Lemley Lofts project, which has been proposed by the Successor Agency. The resolution that's proposed is authorization for the Successor Agency to enter into negotiations with the developer to amend the DDA, the Disposition and Development Agreement, as well as to enter into negotiations with the county as well as other taxing entities in order to reach a tax sharing agreement. I appreciate staff's comments and the note that they would not speak on our behalf, and also wanted to confirm that there have been preliminary discussions regarding this project and potential agreements. I wouldn't go so far as to say we agree that it's a model. Those are staff's words, not ours. But there is a concern with county's understanding of the proposal as well as the item as it's currently listed on the ROPS as item number 14. The existing DDA, which we have had an opportunity to review, does provide a reimbursement to the developer for construction up to the amount of $1.5 million. That is the amount that we understand to be an enforceable obligation pursuant to Health and Safety Code Section 34171D1E, which provides that an enforceable obligation includes any legally binding and enforceable agreement. The amendment that's proposed, that staff mentioned, was approved by the city and the agency in November 2011, was, as he mentioned, invalidated. Therefore, it is not legally binding and enforceable. So the additional $1.1 million that was proposed to infuse into the project should not be listed on the ROPS. And so that's something that the county would ask that you take a look at when you move into the next item. That's our preliminary issue, and we just wanted to encourage the Oversight Board to look at the enforceability of that additional $1.1 million as opposed to what we understand at this point to be an enforceable obligation. Also, as a point of information, the Department of Finance has released a notice on its website that it just basically advised that September 4th is when it will start imposing the late deadlines for ROPS. So you do have until then. That's a concession they're giving in light of the Labor Day holiday. Thank you.
Yeah, that helps. Yes.
So just a point of clarification, you talked about item 14 and the 1.1, and I thought it was my understanding we weren't putting it on this ROPS, it would be in January?
The next agenda item, which is ROPS 3, is for the period of January to June 2013.
Yeah.
But it must be approved now to meet the deadline.
Mr. Kasanjian. Oh, Mr.
Mr. Chair,
he's on 4A also.
In response there, one point that you should know. We did propose to put it on this ROPS so that if everybody was in agreement, it could happen. The Department of Finance did not allow us to amend those agreements. The ROPS. Once they were submitted, they did not allow us during the last round. We don't know whether they will or not, so we put it on this one. If we were forced to push it out, as the county suggests, we would lose the timing and potentially create additional cost on the Alex Theater project. So that's why we've included it here. We put safeguards in so that the money doesn't get spent unless everybody agrees.
Thank you. Mr. Kasanjian.
Good afternoon. My name is Aram Kazazian. I'm going to be speaking a couple of different items. Number one, the MONA. I don't know if you realize, if you read this chart correctly, there is a total of $5.9 million to the MONA. It's split in two different areas. One is 3.6 for the walkway area on the last page, and the other one is the 2.3 million. So that gives you $5.9 million. That money, maybe it would advise attorney, could be returned back with a $315 million that has been borrowed from City Glendale General Fund into the pumping into the development agency. That is a obligation, so that could be used to return back. I hope that's the right way to do it. I know we cannot use soccer field. It's too bad. We're closing the skateboards too now. Then the second item, I'm really disturbed with these Lumley Lofts. I've been here all along from day one on Lumley Lofts because I did see a big problem with Lumley Lofts from the first day that came up. Now, the Lumley Lofts should be denied completely. That has not been approved technicality-wise, sir. That was never, it only has 2 votes on it. It has 3 votes on the first phase of the project with no parking, and then only had because one council member dropped out. It came down second time, so the second time it did not pass. So they amended it to go to give them $1.5 million for 44 parking spaces, which cost exactly $800,000 worth of cost. So they doubled that. They gave him another gift because Starburst said he was a billionaire.
Not to interrupt you, but I think your remarks are better played before the Successor Agency.
Sorry, I apologize. I just got involved in it. What happened is the $1.5 million was given to add the 44 parking spaces. That was done a second go around, and on the second phase of the design review board. But the first phase was approved with no parking and no money. But when it came down, the time to do the second phase, it didn't pass. So that second phase was after the redevelopment agency was dissolved already. The Governor Brown had already dissolved it. They should have never approved that second phase at that time because it was gone. Redevelopment agency didn't exist at that time. The time had expired. So if you go back and look at the exact paperwork dates and all, unless it's been doctored up, it doesn't exist. And now they want another $1.1 million of our money. That money could be returned back to the general fund.
No.
Your time is up, Mr. That's all the speakers I have. Are there any further comments or discussion?
Well, on the I can defer to staff in terms of the litany of dates that were rolled out, but I think I even heard the County of Los Angeles' council characterize the 1.5 as an enforceable obligation, that the Lemley deal, as contemplated originally, is indeed an enforceable obligation. Apparently not one that can just be, that couldn't be terminated, but one that, if it is terminated, would very likely result in a breach with serious legal ramifications to the successor agency. So the question that we would have does go back to that disposition of assets and that piece, that $1.1 million, which is kind of the crux of what we're talking about.
No, what I was just saying is, let's clarify that the money doesn't go back to the general fund.
Yeah.
I mean, we don't get them. If that happened, it would be great. I'll terminate a lot of these and divert them to Alex maybe. But no, really, I mean, we don't have the authority to terminate a project and give the money back to the general fund. I wish we did, actually. Some of these projects shouldn't be here, but we don't. What will happen is the money would go and then be divided between the taxing agencies in the county and the water and the school district and all the other taxing agencies. So it doesn't go back to the general fund. It goes to outside the city of Glendale to other taxing agencies, which is fine. I don't have any issues with that. If there's a project that shouldn't be there, they shouldn't be there.
Actually, it goes to what we represent.
Exactly.
As a board.
Exactly.
Because we represent all those entities.
That is
There's
exactly
members
right.
from.
But it doesn't go back to the general fund.
To be used for those quality of life items
Right.
that folks would want. No.
Is there any other comments or discussion? Because if not, then
yes,
we'll...
Mr. Chair, it's just a question. So it sounds like, and I appreciated County Council's remarks, so it sounds like the county isn't completely on board yet with this tax sharing agreement.
I'll let council respond after, and I hope I was clear. We are just in negotiation with the county. They have not approved it. We're at a staff level, so it is not something that's done, approved, or anything. The staff that we are working with understand what we're trying to do. Council obviously is working with them, and they have this question. And what I'm posing to you as staff of the Successor Agency is that allow us to do this, to leave our options open. If we put this on the ROPS and the county said, or the taxing agencies say no, we can't spend the money. If we put it on the ROPS and everybody agrees, we can spend the money. If we don't put it on the ROPS and everybody agrees, we can't spend the money. So we thought that this was the way that kept the spirit of 1484, kept our options open, our alternatives open, and allows us to work through with the county staff, school district staff, college staff, water district staff, everybody we need to.
To add to that, this ROPS is for January to June. So again, if it was decided that we could not spend the money, we still have 4 months to make that determination before we're allowed to make the first payment, which wouldn't be until January 2013. And the same applies to the MONA discussion before. So just by saying yes today doesn't give us the right to write a check tomorrow. We have 4 months until we hammer out the issues, and the first check doesn't go out for ROPS 3 until January.
So if we put the $1.1 million on the ROPS today, we're saying that it's an enforceable obligation, right?
Subject to the taxing sharing agreement, which is footnoted on the ROPS.
But the county has to agree before it would be considered a truly.
And that's how we would send it. And that's how we would send it to DOF with the
correct.
footnote.
Correct.
Mr. Sheenan?
Correct.
I would like to know our council's take on what Mr. Lansafame said. Before you speak, I do want to hear what you have to say, but.
I think the main issue is the $1.1 million and how it's actually listed on the ROPS. And currently, how at least I understand it, is that the tax sharing agreement is pretty much a condition to the amendment of the DDA. And because, unfortunately, we're kind of asked to look forward, the board is asked to kind of look forward 4 months, we're placing the $1.1 million on the ROPS, or what's requested of the board is to place the $1.1 million on the ROPS with a footnote stating that this will only move forward if the tax sharing agreement actually is in place. So I hope that answers the question.
And this follows in what we were talking about earlier, which is, in essence, what you would be doing is you would be deciding under this Section E that an amendment to this agreement can be pursued, because you're not approving it at this time, but can be pursued if you believe it's in the best interest of the taxing entities. So if this body today feels that an exploration of this issue might be in the best interest of the taxing entities, then we do not have a problem putting it on the ROPS with the condition as indicated that it be subject to the tax approving agreement, because, as we say, just the fact that it's on the ROPS doesn't mean that it's approved, and it doesn't mean that the money is spent. And again, ROPS being a financial reporting and allocating system versus this section, which is an operational issue, so they don't track exactly the same way. It's our view that you have an ongoing authority under Section 34181E to declare that you're not going to amend it, that you are going to amend it, and so on. What staff over here is saying is that if you don't put it on the ROPS, then they're not going to be able to do the deal. It's my view that you're not giving up the alternatives to disapprove the amendment once it comes to you in a more solid form. It's difficult to even think about whether or not it's in the best interest of the taxing entities when it's still in baby stages. But if you authorize it to go on the ROPS, then you preserve the right to later sit down and listen to staff's presentation about what they did negotiate and what good it will do for the taxing entities, and then make a determination, yes or no.
But even then, it's all subject to Department of Finance.
Exactly. I mean, eventually it'll all go up to the Department of Finance, and who have been given
their treatment.
They've been given authority previously allotted only to the gods.
The Speaker?
If I may respond to Board Member Steiger's question regarding the county's position, we have, been in preliminary conversations regarding the amendment to the DDA. We were only provided the original DDA yesterday. One of our departments was provided with it yesterday, and we only had an opportunity to review it today. After reviewing the DDA under those circumstances, we understand Exhibit 11 of the DDA to provide a reimbursement agreement to the developer. So the way that the money would flow in this transaction is the developer assumes the cost of construction, requests reimbursement from the agency, and then the agency provides payment in that form. Just from that understanding, it's not clear to me why the $1.1 million as an estimate that has not been confirmed yet and has not been basically written into an executed agreement at this point is an enforceable obligation, as opposed to authorizing the successor agency to continue with these negotiations, to present you with an executed agreement, and then have that process that's already written into the existing DDA where the developer constructs, submits reimbursement requests, and then those reimbursement requests go on to the ROPS 4 for the second half of next year.
I have to say that counsel makes a good point, but the problem is the law is the way it's written does not, cannot, and probably never will address all of the factual variations that are going to come before you. What we have here is a factual variation which has a timing component, and in a perfect world, yes, you'd like to see a already determined and approved enforceable obligation before you list it on the ROPS. But if it can't survive the delay, which is what I heard Mr. Lansafame say, then I think that the public policy is best served. In these circumstances, I always revert to what's the public policy. The public policy is best served not by adopting a very strict technical reading, but adopting a reading that says, ultimately what we're here for is to liquidate assets in a reasonable way that causes the best possible, highest possible reward to the affected taxing agencies and distribution of funds to them. If you're precluded from even making that determination by such a technicality, I don't think that serves the public interest.
Thank you. Are we ready?
I'd like to call for the question.
All right. Well, do we have a motion to accept the resolution?
I would make that motion to accept Resolution 4A1 and 2.
Second?
In that resolution, clearly indicating that the ROPS will show it as a conditional approval. Right. All right. Thank you.
Roll call, please.
Board members Abkarian.
Abstain.
Yes.
Nakasone.
Yes.
Ochoa.
Yes.
Sheehan.
Yes.
Steger.
Yes.
And Chair Raggio.
Yes. The two resolutions passed. We're starting to get tight with time, so.
Yes. Moving on to ROPS 3.
Let me read it.
Oh, I'm sorry.
At 4B is Director of Community Development regarding recognized obligation payment schedule, ROPS, for January 1st to January 30, 2013, ROPS 3. At 4B1 is resolution adopting recognized obligation payment schedule, ROPS, for January 1st to June 30, 2013, ROPS 3, and administrative budget for a period of January 1st to June 30th, 2013. At 4B2 is resolution directing Successor Agency to implement certain projects and report back to Oversight Board.
Before you, we have ROPS 3, which covers the period of January 1st, 2013 until June 30th, 2013. Approval of this ROPS is requested from the board, and by approving the ROPS, you're following staff's recommendation to make certain payments beginning January 2013. But because AB 1484 provides for additional time with back and forth with the Department of Finance on any disputed items, that's why you're considering this so early on, because they have 400 agencies throughout the state, and in order to provide ample time to review disputed items, the review and approval must be submitted now. The ROPS format has changed from when you first considered ROPS 1 and 2. Specifically, the Department of Finance has asked for not only what we estimate in payments going out for this 6-month period, but they've also asked for us to go back to our ROPS 1 and reconcile what our estimated costs were and what we actually paid out. So going back to Mr. Kazazian's comment that the Mona project is listed twice, it is listed twice, but that's what the form asks us to do. Tell me what you need for ROPS 3 and tell me what you used up for ROPS 1. So it is listed twice, but it's not double counting the amount to be spent. So I wanted to clarify that. The two items that were disallowed during our ROPS 1 and 2 review, which were the city agency loan and the 20% commitment towards low mod housing, have been removed. You don't see them on this ROPS because they were disallowed. And let's see, what else do I want to cover here? We have different sources of funding, which go back to the AB 1484 staff report and AB 1484 PowerPoint presentation, where we have some cash on hand, and part of the reason we have this cash is because the DOF disallowed our payment back to the city of Glendale to pay back a loan they had lent to the redevelopment agency. So we had some cash balances left, and we are using some of the cash for ROPS 2, and whatever's remaining we have placed on ROPS 3 to be spent from cash. The balance is listed as bond proceeds, and additional money is requested from the RPTTF to cover obligations on our ROPS. The way we've laid out the ROPS is we've tried to group the bonds, loans, and different agreements together, and have cited the code section so that if somebody wanted to read the legislation and find out why a specific item is on the ROPS, they can do so. The new format by DOF also asked us to provide notes where we needed to explain things, because the format of the ROPS is very limiting. You just put a dollar amount and when you anticipate to pay it out and the title of the project or obligation. And so the notes page was very helpful to us in explaining some of the conditional items, such as the two that you just reviewed. And so there are footnotes where necessary to explain items, and part of the ROPS is the administrative budget. So what will it cost the successor agency to wind down the redevelopment agency for this 6-month period? And for our agency, it's about $350,000 for about 6 staff members. Let's see, that covers the ROPS and the administrative budget. At this point, I'd be happy to take specific questions, because there isn't enough time to go through each line item, so I'll open it up to any questions on the ROPS at this point.
Questions from the members of the board?
I have a question.
Mr. Nakasani?
If we use the excess cash that we saved from the things that were denied from the Department of Finance for ROPS 2, when they do the due diligence, so we're going to have problems and they're going to be looking for cash that's not there?
as of right now, without the clear guidelines being out there on the due diligence review, our understanding is that as part of the due diligence review, they'll look at the available cash and what is committed to a ROPS item, and the balance is to be remitted. So what's not committed to the 20% housing set aside and the city agency loan will be available to be distributed to the taxing entities.
When you talk about the use of cash, that's coming at the direction of DOF? Use on-hand cash as opposed to using...
Correct. In fact, the legislation tells us to use our cash before we list the RPTTF as a funding source.
They want you to get out of the property tax payment business or collection business.
Correct.
I have two speakers. Mr. Allen. Again, 3 minutes.
Thank you, Chair Raggio, and I don't think I'll even take 3 minutes. Probably the amount of time that everybody has taken looking at all of the ROPS information that you've been given and drilling down to see what those administrative budget costs are that you're going to approve for the successor agency and all of the other detail that is there in front of you in line items for very broad purposes. And as an oversight committee that does have immunity, I think it's still necessary to dig down and look at those costs that are you're going to be approving. And fortunately, the DOF will make the ultimate decision. Thank you. I'm Barry Hammond.
Thank you. And Mr. Kasanjian.
And Elena, as Mr. Kazazian comes up, everything that's on this ROPS has already been, in previous ROPS, been approved by Department of Finance?
Correct.
Okay, Elena, thank you for answering that. But the reason I was talking about, if you look at the ROPS, the first page, you have the MONA listed as $2.3 million.
Which item are you looking at? And then the number right on the left side?
The 13.
There's a number at the left edge.
Number 13.
All right.
It's 2.3 million. I'm not saying it's listed twice, but on the last page, item number 79. 79 is the Paseo, which is 3.6 million. That is the passageway to the MONA. So that is part of the MONA itself, because they're going to tear the building out to put a passageway into the side of the MONA. That's why it's a 3.6 million. There's an existing building, 50 feet wide, 150 feet. They're going to tear it down, put new concrete, new pavers in, and that is a 3.6 million. So the total cost of MONA still comes up to 5.9 million. That's what I was trying to say. Am I right or not?
I'll wait till you're done and then answer the question.
Oh, okay. That's the only thing. But a lot of these items really. It's not appropriate, but I won't comment anymore. That's what I'm going to pick on right now. Thank you.
The line item that Mr. Kazazian is pointing out, which is line item 79, that is improvements, and the description is Paseo Parking Lot 10, development of a mid-block Paseo and reconstruction of alley parking lot, $3.6 million from our bond proceeds. That is different than the MONA agreement, which obligates the agency to make landlord improvements to the building in order to get it ready for MONA to operate. So they are different.
But Elena, the creation of that Paseo connecting our Central Park to Brand Avenue and the downtown, it serves the purpose unto itself.
Correct.
Right? I mean, it's a local circulator and connector, as opposed to being the express use of MONA. If MONA doesn't go away, we can still build that Paseo.
Correct.
And
we will.
Any further discussion with respect to these two resolutions?
I do want to point out we also are asking the Oversight Board for approval. There's two sections, 34180 and 34181 of the Dissolution Act, that ask you, the Oversight Board, to approve certain actions that the Successor Agency takes, and ask the Successor Agency to get approval from the Oversight Board on certain actions. There's a lot of back and forth, and knowing that you only are able to meet once a month, and we have certain projects that we would like to move forward with, we are asking your approval to allow us to move projects forward to the extent they don't require your approval, and to the extent that is the limit is what's listed on the ROPS, so that we avoid taking items to the successor agency and bringing it back to you. And this is specifically for different phases of a construction project. So we want the ability to move forward with projects and only bring it back to you if we need additional money, or if your approval is needed. So we're trying to streamline the process within the confines of 1484.
If I may add, and these are existing enforceable obligations that have been approved on the ROPS within the timeframes and the financial limits as stated.
But if it doesn't need our approval, why would it come here anyways?
Because 1484 says so.
It's the
Come in
law.
for us to do it.
What's the pleasure of the board regarding these two resolutions?
I'll make the motion.
Is there a second?
I'll second.
Roll call, please.
Board members Abkarian,
Yes.
Barry,
Yes.
Nakasone,
Yes.
Ochoa,
Yes.
Sheehan,
Yes.
Steger,
Yes.
and Chair Raggio.
Yes. Motion's pass. And I have one card for oral communications. Mr. Allen.
Discussion is limited to items within the jurisdiction of the Oversight Board. Each speaker is allowed 5 minutes. Members of the Oversight Board may question or respond to the speaker, but there will be no debate or decision. The matter may be referred to staff through the Executive Director of the Successor Agency for investigation and report.
We should have one just a limited time just for Mr. Allen. Mr. Allen could come and talk for 10 minutes and be done. He doesn't have to come back
we
again.
We limit the amount of time, but not the number of times. There's that difference. I do want to address one thing, that there are a number of people here today who, like many of you, aren't really familiar with the core of the Oversight Committee. And they have brought information to you to help you make a decision that the City Council, sitting as either the redevelopment agency or the successor agency, has not done according to Hoyle. But I applaud each of you for your willingness to serve on this most important committee, a committee that came about because of the wisdom of the California legislature and the Governor Brown. The act creating the redevelopment agencies was to reduce blight. Unfortunately, as city councils were the development agencies, they forgot their fiduciary role to the voters. They expanded the purpose of the redevelopment agency law. The GRA became home to entitlements, payroll, and benefits burden, and a debt in Glendale of over $1 billion. Had the state not said stop, there's no telling where the debt would go. The Disney rebate of the property tax perverted the purpose of using those dollars to repay loans. $127 million could go to schools, debt repayment, and a better quality of life for the stakeholders. If Glendale is the business-friendly city that some purport it to be, it would not be necessary to give financial incentives to build nor to do away with parking requirements. The law, and especially AB 1484, give considerable power and authority to this oversight committee. Please correct the actions of the council that sat as the GRA and now the successor agency that have created more problems than the stakeholders can afford. There has been at least one lawsuit filed on behalf of a bond indemnity corporation that is yet to be heard, and that is in Sacramento now, against the DOF and the County of San Bernardino. Glendale participated in another that was dismissed against the act itself. AB 1X26 was upheld by the Supreme Court. Read the laws that formed your committee, then ask the staff to comply with them. In one resolution, staff left out your right to terminate projects. But now that you have competent legal counsel to advise you, I think you're going to be much better off. And I thank you for your willingness to serve. I'm Barry Allen.
Thank you, Mr. Allen. Board members, any staff comments? Board and staff?
Just looking for, looking forward to on your next meeting schedule. We certainly will not have the due diligence review completed by the September 5th meeting, so if it's the board's desire, we can go ahead and cancel that meeting. And if we are able to get the guidelines, get the CPA firm on board and have it completed sometime in September, we could certainly look at scheduling a special meeting in September. But as of right now, October 3rd to hold the public hearing, which is also a new requirement of AB 1484, is that you meet, open up a public hearing so the public can come look at the due diligence review, and this one would be specific to the housing items. Then a week or a few days later, then you actually, once you've heard the public, then you take up the item. So at this point, we'll leave October 3rd and October 11th, but we will be in communications with you. If any of these dates need to be pushed out, then we will certainly communicate that to you. But that's what
Thank you. Thank you for the 5th of September. Albert?
Yeah, my suggestion was to cancel September 5th and then see how we can arrange everything else. That was one of my questions. And the second question that I had was, if each member of this board has a question for our legal counsel, how do we handle that so we're not, there has to be one channel that basically that goes through, so we're not keep calling and all of a sudden our legal fees goes up to...
I think you go through Mrs. Bolbalian.
I think having to go through staff, if analogous to what we would do as city staff, is it goes to a point staff person, goes to legal. That way they aren't inundated, and that answer comes back to the staff and gets shotgunned out over everybody, unless it's a confidential matter that otherwise couldn't be.
I think that's a good way to do it, because they're going to be able to answer a lot of the questions that would come to us and do it without incurring any greater charge. So I think that's an excellent way to do it. I did want to add one little housekeeping thing here today, because both Ms. Rahi and myself are present here. That's two attorneys. And I wanted you to know that quite often the two of us will be here, but you will never be charged for more than one of us being present. It's our choice to have the other present, so that we both stay as on top of your issues as possible. Clearly, sometimes there's going to be conflicts or court hearings or whatever where one of us can't make it. So it's our decision to have the other here at no cost to you, so that we don't lack any background information.
Well, also, it's because we're so entertaining.
I know. We're all fighting at the office to be here.
So, what better way to spend an afternoon, huh?
I can't think of one.
Yeah, the oversight matinee. So, any further board member or staff comment?
Yes, Mr. Chair. So for our next meeting, council's going to come back with the analysis on one. Okay.
Any new business? If not, I'll entertain a motion for adjournment.
Move to adjourn.
Second.
We are adjourned, and thank you all.